Hi there. I'm Ron Urbach. I'm chairman of Davis and Gilbert, a law firm located in New York City. We are the United States representative for Gala. Advertising is regulated in the United States through a series of federal, state, and local actions and agencies. On a federal basis, the main agency is the Federal Trade Commission, located in Washington, D.C., and in a number of offices around the country. They have jurisdiction over advertising that is false, deceptive, misleading, or unfair. On a state basis, each state has its own attorney general that can bring its own statutory violations and actions against advertising and marketing practices. On a local basis, there are a number of municipalities and counties that also have their own set of advertising laws and regulations, and they can bring direct actions on their own. In addition to the regulatory actions, there's an ability in the United States to bring consumer actions. These consumer actions can take the form of consumer class actions, which can be brought in federal and state court around the country. And the critical concern in this regard is that they not only proceed on the basis of injunctive relief, but large monetary damages, and specifically demands for significant attorney fees as part of the process. The final area of regulatory involvement on a self-regulatory basis is going to be competitor challenges. On a competitor challenge basis, each competitor can bring direct action in federal court for false, deceptive, and misleading advertising under the Lanham Act. When you go beyond challenges, the self-regulatory body that we have to deal with in the United States on a regular basis is the NAD. It's the National Advertising Division of the Council of Better Business Bureaus, located in New York City. It has an ability and jurisdiction to take action with respect to national advertising and regional advertising as well. The result of it is that there is no monetary awards that occur, but there is an ability to get the advertising to stop by way of the power of the press and the power of public pressure. NAD actions can be brought directly by competitors, and they can also be brought by consumers and the NAD itself. It is an extremely activist agency. Some of the common mistakes and issues that you have to worry about today in the U.S. is the use of social media, digital media, and mobile media. That is the area where the intersection of content creation and advertising and regulatory concerns are at the forefront. You need to understand that when you work in this area, the laws and the issues are of tremendous focus by all of the constituencies in the U.S., the regulators, the challengers, the competitors, and the consumers. So as you work in this area, you need to think about all of the legal issues that occur on a national, federal, and local basis, and you need to consider what is in fact advertising and what is in fact content. That is a fundamental issue that exists in this country today. The result of it has been that we have had a number of leading edge actions being brought by the FTC and by consumer class action every time a new social media company and service comes out. The most recent has been the development of personal video streaming, which occurs with Mercart, and with respect to Periscope, just recently launched by Twitter. In that regard, the key question that has to occur is, what is in fact this content? Is it advertising? Is it marketing? Or is it content? And whether or not that decision is advertising or content will determine what is the level of regulatory and legal concern that exists.